Assalamualaikum warahmatullahi wabarakatuh and good afternoon to our lecturer and all my friends. So today we are from group 1 of TLB1. We would like to present our assignment which titled Freedom of Association, Political Stability and the Prospect of Anti-Hopping Law in Malaysia. Firstly, I would like to introduce our group members. My name is Afiq Muhammad Shukri and my friend Hafizah binti Muhammad Rosli and Zulaikha binti Zaidi. So, firstly, I would like to explain about the freedom of association. So, what is the freedom of association? The freedom of association is one of the fundamental liberties guaranteed to every citizen in Malaysia. According to Article 10, Clause 1, Clause C of the Federal Constitution, all citizens have the right to form associations, which means a citizen in Malaysia has the guaranteed rights to form, to join, not to join, or resign from an association. However, according to Article 10, Clause 2 of the Federal Constitution, on the right conferred by Paragraph C of Clause 1, such restriction as it deems necessary or expedient in the interest of security of the Federation or any part thereof, public order or morality. Which means in this article, it states that the right of associations can only be restricted by the laws enacted by the Parliament under the circumstances as prescribed therein. So next, I would like to continue on restrictions to freedom of associations. As His Lordship, the late Raja Azlan Shah, who was the Lord President of the Federal Court, stated that there cannot be anything as absolute or uncontrolled liberty wholly free from restraint, for that would lead to anarchy and disorder. What the Constitution attempts to do in declaring the rights of the people is to strike a balance between liberty and social control. In other words, there must be a limit to everything. Nothing is wholly free or without restraint. For example, a distinction must be drawn between campaigns that are conducted in a civil manner and which invite mature discussion and debate on issues of concern, and campaigns that affect national sovereignty, national security, and public order. According to Article 10, Clause 3 of Federal Constitution, restrictions on the right to form associations conferred by Paragraph C of Clause 1 may also be imposed by any law relating to labour or education. For example, in Universities and University College Act 1971, in Section 15 Clause 1, subject to Subsection 2, a student of the university may become a member of any society, organisation, body or group of persons, whether in or outside Malaysia, including any political party. However, in Section 15 Clause 2, a student of the university shall not become a member of any political of any unlawful society, organisation, body or group of persons, whether in or outside Malaysia, or become a member of any society, organisation, body or group of persons, not being a political party, which the board determines to be unsuitable to the interests and well-being of the students or the university. So in this act, we can see that Section 15 Clause 1 talk about the right of the students, and the Section 15 Clause 2 about stated the restrictions of the freedom of association.
So, we have gone through the constitutional basis of the freedom of association. However, even though the freedom of association is provided in our federal constitution, and so it is legal to join or to leave any group or associations, but we have to analyze what are the effects of this freedom of association towards the political stability. So next, we will go further and look deeper into the political stability in Malaysia. You must be wondering, what does the freedom of association have anything to do with the political stability? According to the global economy, the Political Stability Index, which is the average of several other indexes from the Economist Intelligence Unit, the World Economic Forum, and the Political Risk Services, among others, Malaysia have the Index of Political Stability of 0.12. The index that shows a stable political situation is 2.5, which means currently Malaysia has a very low index of stability of politics. If we analyze the chart, we can see that during 2018, we have a higher index of political stability, meaning that we have a more stable politics in our country during that time. Can you recall what happened in 2018? Definitely the 14th general election. At that time, we have a change of government, but why is that the political condition is still stable? This is because we follow the fair democratic process. We follow the choice of the majority of the citizens without much deceptive tricks justified under the name of freedom. This is what determines a political stability in a democratic country when a mature, fair democratic process has been applied. However, the politics then becomes unstable and the political instability of Malaysia becomes much worse and worse during 2020. How does this relate to the freedom of association? Freedom is good, but an unlimited freedom is poison. Provided the freedom of association, every citizen in this country is guaranteed with the freedom to join or to leave any groups voluntarily, including the ministers. They are not prohibited to join or to leave any political parties. Switching between parties, this is what we call party hopping. In 2020, several ministers have switched parties led by the Deputy President of PKR, Datuk Sri Azman Ali, who left the party. This whole event is called the Sheraton move. Switching between parties makes the government lose its support of majority. And so we can see, in just 1 year, we have 3 changes of Prime Ministers, starting with Dr. Mahathir, then changed to Tan Sri Muhyiddin Yassin, and currently Datuk Sri Ismail Sabri. This clearly shows the instability of the governmental power. The government will easily lose its power due to the party hopping. Do you think it is good to our politics maturity? Definitely no. A political observer, Datuk Peter Minos, has stated that party hopping is simply no good to politics, political stability, the nation, the voters and the people. The people are definitely fed up with the party hoppers because they are big disappointments and a disgrace. The hoppers make politics very cheap and this is intolerable. Of the effects of party hopping towards political stability are, firstly, the public society lose faith in democratic process. Secondly, important principle of democracy is not being upheld. And thirdly, high risk of changing of governmental power. The 2020 political crisis in Malaysia is still ongoing until today. Hence, we have to have a law or a mechanism of control to prevent party hopping in order to gain our political stability.
Assalamualaikum, my name is Zulaika binti Zaidi. So now I will continue with the last part of this presentation regarding the anti-hopping law in Malaysia. Generally, the desire to create this anti-hopping law used to be the topic of the discussion in our country's political world as early as 1978. So the term party hopping in political matters, it refers to the members of parliament where they switch their political parties midway through their tenure of service. So this anti-hopping law is desired to prevent persons who are elected under the ticket of a political party from crossing over to another political party after they win a seat. According to the Minister in the Prime Minister Department Parliament and Law, Datuk Seri Dr. Wan Junadi Tuanku Jaafar, he clarified that there are 3 main criteria that define party hopping by a member of parliament. Firstly, when the members of parliament, the MPs, who wins an election and then they announce their departure from the political party, for instance by stating that they will be an independent member or they will join another political party. Secondly, an MP who has won a parliamentary seat but is expelled by their party. And lastly, an independent MP who joins any political party after winning in an election. Next, regarding the anti-hoping law bill in Malaysia, till this date, actually there is still no prohibition for the members of parliament to switch parties owing to the freedom of association under Article 10 of the Federal Constitution. Furthermore, there are still many parties who dispute the significance for the government to proceed with this anti-hoping law bill, because in order to do so, it means amendment also must be made to Article 10 of the Federal Constitution, which pronounces the right of freedom of association. It means a citizen has the guaranteed rights to form, to join, not to join or to resign from any association. So for the parties who still dispute this importance of anti-hoping law, for them, by imposing a penalty for party hopping, they deem it as a violation to the freedom of association guaranteed by the Federal Constitution. However, back then, some state constitution used to prevent this party hopping, as can be seen in the case of Dewan Undangan Negeri Kelantan and Nordin Saleh 1992. So in this case, it involves two elected representatives by the name of Nordin Saleh and one Najib Wan Muhammad who had resigned from their party Semangat 46 to join UMNO. So they were the elected representative of Sungai Pinang and Libongan constituency. So a lawsuit was brought by the Sungai Pinang State Assemblyman Nordin Saleh against the Kelantan State Assembly, which approved a provision to prevent the aduns from changing parties. This is because in one of the Kelantan State Constitution article, it mentions that if any member of the Legislative Assembly who is a member of a political party resigns or is expelled from or for any reason cease to be a member of such political party, he shall cease to be a member of the legislative and his seat shall become vacant. So on April 3, 1992, back then it was known as the Supreme Court, they ruled that the Kelantan Dun's decision to pass such enactment banning party hopping was unconstitutional, as it violated Article 10 of the Federal Constitution because it affected the right to freedom of association. Lastly, the rationale of anti-hopping law. This anti-hopping law is actually important in order to maintain or to preserve the political stability in our country and also to ensure the public faith in the democratic process, as well as to ensure the voters' decisions are respected. It is also crucial to uphold the important principles of constitutional and electoral rights. Anti-hopping law also is important to prevent immoral representatives of political parties from continuing to exploit their position, for instance, for their personal gain or monetary or at the expense of their voters itself. It is also to make sure that the will of the voters is not hindered by irresponsible elected representatives, because after all, party hopping is deemed problematic and it is kind of the betrayal of the voters' mandate. So that's all from our group today. Thank you.